Rights, Your Excellency.
Says what?
It says that individuals and NGOs will only have the direct access to the courts if the state has made a separate declaration subsequent to Article 34.6 of the protocol.
Proceed.
Much of that, Your Excellency. Yeah. Your Excellency, subsequent to the fact that the respondent states has successfully withdrawn its declaration, this treats this court of the jurisdiction to actually sit on this matter, Your Excellency. Your Excellency, this withdrawal was made before the applicants approached this court. And after the withdrawal was made, the applicants still approached this court, knowing fully well that the state has withdrawn the declaration that gives them the right to approach this court. Your Excellency, on this, playing from these arguments and playing from these authorities, the respondent concludes and submits that this court lacks the jurisdiction to entertain this matter.
Yes.
For this honorable courts.
Yes. But the applicant has argued that the withdrawal in question is invalid based on the Vienna Convention on Law of Treaties. Can you educate this court or address this court on the validity of withdrawal of Article 36.4? On in what circumstance will it be said to be invalid or valid under international human rights law?
Much obliged, Your Excellency. Your Excellency, the Vienna Convention that the applicant has referred to has to do with treaties and conventions, Your Excellency. In this particular case, what you are dealing with is a protocol, a set of protocols and declarations, Your Excellency. To equate declaration with protocol, to equate declaration with treaties does not follow logically, Your Excellency. The Vienna Convention only has to do with treaties and conventions ratified by countries. The old treaty itself, that is what the notice in the Vienna Convention is all about. However, this particular declaration in the protocol to the African Court of Human Rights is not a treaty, Your Excellency. It's not a convention. It is a declaration that can be solely withdrawn, and that can be solely withdrawn by the state at its power or at its choice, Your Excellency.
Proceed.
Much obliged, Your Excellency. After addressing the issue of jurisdiction, Counsel would now like to elaborate on the first issue, or the first substantive issue in this particular case. And Counsel will be doing that.
Before you proceed, can you talk about the issue of admissibility? Address the court on the issue of admissibility.
Your Excellency, admissibility on what, Your Excellency?
Proceed if you do not understand the question. Proceed to your argument.
Much obliged, Your Excellency. Counsel would like to elaborate on the first issue, which is whether the declaration made by the respondent state is valid under international law and under the protocol. Your Excellency, Counsel will be relying on 3 years of submission in elaborating on this particular issue. And one is that the withdrawal is valid under the protocol and international law. Second is that the withdrawal does not violate the African Charter. And third is that the withdrawal does not violate any vested rights of adherents. On the first side of submission, Your Excellency, Counsel submit that this withdrawal gives state parties the option and not the obligation to grant direct access to individuals and NGOs. Your Excellency, it's a voluntary and unilateral act. And in the case of Ingabria and Rwanda, citation duly supplied, the court affirmed the rights of respondent state parties to withdraw their declaration at any time they deem fit. Based on the second, flowing to the second issue for second aids of submission, Counsel for the respondent submit that the withdrawal does not violate the African Charter or other human rights instruments. Your Excellency, the African Charter does not guarantee direct access to these courts. The first mechanism is the African Commission, Your Excellency, and that mechanism remains fully available to adherents. So, flowing from this, Your Excellency, the Republic of Adherents has not withdrawn from the Charter, the protocol, or any treaty protecting rights. What they have done is to withdraw their declaration of a particular aspect of the protocol, Your Excellency. Your Excellency, based on the third issue of submissions, the Counsel for the respondents affirmed that there is no vested rights that has been undermined by the respondent states. Your Excellency, this application was filed after 15 August 2025, when the respondent states has already withdrawn their declaration. Your Excellency, this particular act of the applicant shows that this withdrawal bars them from approaching this honorable court in insisting a case since the withdrawal that the declaration that gives them the rights has already been withdrawn. Council will proceed based on the second issue of submission, which state that whether the Republic of Nigeria failed to protect the Bashish people and child workers from violations by the Queen's Line Only Limited. On issue 2, Your Excellency, the respondent submit that the Republic of Nigeria did not violate the African Charter or any human rights instruments. Your Excellency, the Republic of Nigeria has fulfilled its duty to protect under Article 1 and under Article 24 of the African Charter. Your Excellency, when tensions arose and protests began, the states did not ignore complaints. Rather, it established a commission, an independent commission to investigate and to look into these matters. And this commission made recommendations, and the states implemented these recommendations and provide compensations to the victims. Your Excellency, this is due diligence. Your Excellency, there was accessible and effective domestic remedies for affected residents. And when property issues...
Councillor, your time is up, but we'll give you 3 more minutes to wrap up.
Much obliged, Your Excellency. Your Excellency, there were accessible and effective domestic remedies for affected residents. Your Excellency, when the relocation and property issue persisted, the affected person did not remain hopeless. Your Excellency, they had the domestic courts whereby they could fight the issues and they could tender their misgivings and they could enforce their human rights, Your Excellency. The matter was heard before the domestic courts, and the High Court heard that compensation had already been provided. Your Excellency, a state that provides judicial remedies, a state that allows grievances to be ventilated, and a state that respects the outcome of its own courts cannot be accused of failing to protect its own citizens, Your Excellency. Your Excellencies, the allegations of child labor cannot be imputed to the states because the people perpetrating this child labor are scattered artisanal miners that were indirectly related to the QHL. Your Excellency, the contrast between the respondent states and the QHL is a contract of service. And under a contract of service, it is an independent contract, and the QHL, they have the prerogative to supervise their own contractors. Your Excellencies, the acts of these contractors cannot be imputed on the states because it's not the act of the states, Your Excellency. Your Excellency, the respondent states has investigated every major allegation. They have compensated victims. They found no evidence of systematic abuses, and they have provided domestic judicial remedies. Your Excellencies, this is a state that has fulfilled its obligations under the African Charter, under the International Labour Organization conventions, and under the other international convention ratified. Your Excellency,
so, but what can you, what, Council, what can you say? What can you say?
It stands in direct contradiction.
What can you say to a state that turns the barrel of gun against its people as a result of exercising their right to freedom of assembly?
Your Excellency, while the states recognize that everybody has the freedom of right to assembly, this right is not an absolute right. And in situations right is being exercised and it is causing danger or causing harm to the government's properties, to the state properties, or to the people at large, these rights has to be curtailed with a reasonable measure. Your Excellency, this is what the state has done. The state has not turned its back on the people intentionally. They have only curtailed their rights in order to ensure peace and order, Your Excellency.
Proceed.
Much obliged, Your Excellency. Council will not seek the leave of this court to defer proceedings to my co-counsel, who will take the issue 3 and issue 4, Your Excellency.
Thank you very much. Council, co-agent, you can speak now.
With utmost humility to this honorable court, F.A. Adiba is many once again, co-counsel for the respondents in this case. Your Excellency, I am to take issue 3 and issue 4 and the prayers hereby adopted earlier. Your Excellency, our arguments for issue 3 is whether the Public Order Act of the Republic of Edea violates human rights law. And Your Excellencies, our heads of submission as arguments are these: that 1, Section 13 is a legitimate prior notification mechanism, which has been put in place and which has been followed by the Republic of Edea. Your Excellency, our second argument is that the 14-day period is proportionate and necessary in the context of the Republic of Edea. Your Excellency, we also argue that no violation arises from isolated incidents and the Republic of Edea complies with positive obligations. Your Excellency, the Republic of Edea submits that Section 13 does not in any way violate this instrument, as it constitutes a permissible prior notification requirement for facilitation purposes on the part of the state, proportionate to legitimate aims of public safety, order, and consistent with international standards. Your Excellency, Article 11 of the African Charter guarantees the right to freedom of assembly, subject to necessary restrictions for public order. Similarly, the ICCPR Article 21 permits limitations solely for national security, public safety, order, health, morals, and other rights, provided they are necessary in a democratic society. Your Excellency, these are necessary in relation to the protest in the Republic of Edea. Your Excellency,
Counsel,
human rights.
Counsel, can you please
Yes,
argue how the right to protest has infringed on this article you just mentioned? How is it that the right to the protest of the people has a direct infraction on this Article 11, which is what you are, the context of the arguments? Please, can you please tell this honorable court?
Your Excellency, much obliged. In the context of Article 11 of the African Charter, the Article 11 of the African Charter guarantees the right to peaceful assembly, the right of citizens to assemble freely, which by implication meant that adherents are allowed to protest. Your Excellency.
So, yes, the question is asking you. The question is asking you is that now you have spoken about necessary limitation to the right to peaceful assembly. So the question now says that based on the facts, can you say that in exercising their right to protest, these people have they in any way run foul of the human rights law as provided that warranted your state to open fire on them and kill hapless and armless citizens?
Very well.
Yes, Your Excellency. Paragraph 12 of the fact states that police responses only stemmed from protesters' stone throwing and the area boys' intervention. This is what justifies the state action in this context, and we rely on the ICCPR Article 21 in justifying our actions in this regard, Your Excellencies.
Yes, but the point is that if you look at it in paragraph 12 that you just quoted, it says that the protests were peaceful. Protesters were carrying placard and chanting solidarity song. So will it not be right to say that it was the coming of the state agency, which is the police, that made the protest to turn violent?
Your Excellency, it is not becoming of state to undertake such action, because part of the case clearly stated that on the part of the protesters, there were stone throwing and there were the intervention of louts and area boys, which escalated into violence in this situation, Your Excellencies.
Okay, can we look at the fact together, paragraph 12? It said, however, when some policemen were deployed to the protest venue, started shooting tear gas. So there was peacefulness in the protest until the state agency started shooting tear gas. So how is it that not the state that propelled or ignited the protest being turned violent?
Counsel, go ahead.
Your Excellency, on our arguments, we argue that no violation arises from this situation, and the Republic of Edea complies with positive obligation, and we acted within the rights of the state, and we acted in due diligence and in support of public safety and order, Your Excellency. So our claim is that... Much obliged, Your Excellency. Your Excellency, we argue that these police responses stemmed from the protestants' stone throwing and the intervention of the area boys. And this justifies the proportionate force which has been applied under ICCPR Article 21, not the notification rule. Your Excellency, the case of Pax versus Gambia
Okay,
affirms Assembly's protection.
Before you proceed, can you educate this court on the protect life principle? The protect life principle under international human rights law as related to management of protest.
Your Excellency, I did not get the question very well.
Can you educate this court on the protect life principle as it relates to management of protests?
Your Excellency, counsel would refer to the question in subsequent times as the proceeding proceeds.
Proceed.
Much obliged, Your Excellency. Your Excellency, on our argument that the 14 days period is proportionate and necessary in the context of the Republic of Edea, Your Excellency, General Comment number 37 permits varying notification periods based on assembly scale location, rejecting fixed maxima, but emphasizing proportionality. Your Excellency, the Republic of Edea's 14 days accommodates logistical challenges in a presidential system with 25 states and strike-prone judiciary. Your Excellency, allowing time for regional coordination without unduly burdening spontaneous expression. Your Excellency, General Comment 37 exempts truly spontaneous assemblies from notification where no harm is foreseeable. Your Excellency, we align with the holding the case of Lashmaki versus Russia, where it was upheld that notification's legitimacy for orders maintenance, finding violation only in arbitrary spatial bans, not timing per se. Your Excellency, the Republic of Edea's provision mirrors this, tailored to mining unrest risk, where advance notice prevents clashes like the 2019 violence. Your Excellency, on issue 4, our argument is whether...
Counsel, sorry. You mentioned the case of what and Russia again?
The case of Lashmankin versus Russia.
What decision of what court is that, and of what effect is it to this court?
Your Excellency, the case is a persuasive case in this scenario, Your Excellency.
What decision of what court is that?
That's the decision of the European Court, Your Excellency, on human rights.
European Court on human rights. So it's persuasive. On what authority?
Yes, sir.
Do you argue that it's persuasive? What's your authority for that?
Your Excellency, the jurisdiction, the Republic of Edea is not signature to the European courts, Your Excellency. So with this, it holds a persuasive effect in cases relating to the Republic of Edea.
Signature or not signatory? Counsel?
Signature, Your Excellency. Much obliged.
Proceed.
Much obliged, Your Excellency. Your Excellency, on issue 4, our argument is whether the Republic of Edea violated African Charter and other relevant human rights instruments by the various treatments meted out on the persons of Mr. Jude and Mr. Marcos. Your Excellencies, the Republic of Edea denies the claim that it violated the right to life under Article 4 or the right to liberty and security of persons under Article 6 of Mr. Jude and Mr. Marcos. Your Excellency, the force deployed during the June 18 protests was not an unprovoked attack on peaceful demonstrators, but it is a force necessary and proportionate, and it is in response to the violent and rapidly escalating security crisis. Your Excellencies, the fact confirms that the demonstration organized by Mr. Jude and Mr. Marcos escalated into a violent riot when it was joined by louds, who caused chaos and destroyed properties, state-owned properties, Your Excellencies. These non-peaceful elements gravely injured 5 police officers and set a police van on fire. The regular police were unable to quell the protests. Hence, Your Excellency, the authorization by General Anthony to give a final and definitive action and the deployment of special forces in this scenario. Your Excellency, this was an operational decision aimed at restoring national security, promoting public and peace. Your Excellency, these acts are justifiable with the aim are justifiable and are backed by Article 11 of the African Charter. Your Excellency, while we regret the casualties in this case, Your Excellency, the state acted only to protect the lives of law enforcement personnel and to ensure the safety of public infrastructure being destroyed by organized criminal elements. Your Excellency, the subsequent arrest of Mr. Jude...
Counsel,
Your Excellency.
I have just one question for you. Just on the last issue you said, I want you to address this court to give us the facts of the Latvia and Russia case, and then also tell us whether the state could have used other less fatal measures. I mean, not little force in terms of quelling the protests or the riots rather than firing live ammunition at protesters. So please, I would like to hear from you.
Your Excellency, in the case of Lashmankin versus Russia, we rely on the decision that the notification made by body protesters or intending protesters is only legitimate for the maintenance of order, and in a situation in order to quell violence as may arise arbitrarily. And Your Excellencies, as this instant case is concerned, Your Excellency, our decisions or the decision of General Anthony in deploying special forces was only a definitive.
Can you just give this court a brief fact of the case of Latvia and Russia? Tell us exactly what happened.
Your Excellency, I do not possess the facts readily available, but the belief of the court, I intend
to proceed to your submission.
Much obliged, Your Excellency. Your Excellency, on issue for Mr. Marcos was not arrested arbitrarily, but the arrest was executed to restore order and to hold them accountable as the organizers of the protests and for the destruction of government and public properties. Your Excellencies, the criminal proceedings against Mr. Judah and Mr. Marcos fully complies with Article 7 of the African Charter, which guarantees the right to have one's cause heard and the right to appeal. They were charged with an offense provided for under Section 18 of the Nigerian Criminal Act 2008. This Section 18 of the Nigerian Criminal Act 2008 prohibits the willful destruction of government or public property. Your Excellencies, the High Court finds them guilty, and their convictions were subsequently upheld by the Court of Appeal on August 11, 2025. Your Excellency, the process afforded them the right to a hearing before a competent court and the right to an appeal to the appellate court, thereby exhausting every means necessary under the ordinary course of domestic remedies available for criminal matters. Your Excellencies, the applicant's arguments that the Republic of Edea violated the African Charter and other relevant international instruments and convention by the various treatment meted out on Mr. Judah and Mr. Marcos is baseless and unfounded. Your Excellencies, the Edea Constitution expressly defines the Supreme Court's criminal jurisdiction in this regard. It is confined to appeals in which a sentence of 5 years or more has been issued without the options of a fine. Your Excellencies, the 3-year sentence without a fine given to Mr. Judah and Mr. Marcos falls outside the constitutional threshold for criminal appeal to the apex courts. The state is not violating their rights, but is applying a clear pre-existing jurisdictional rule in its national legal framework. The absence of a right of appeal to every single court is not a denial of the fair rights, Your Excellencies, provided a higher court has already reviewed this conviction, and this is the facts and the rule which Court of Appeal upheld. Therefore, Your Excellencies, we invite you to reason with us that the respondent that the judicial process against Mr. Jude and Mr. Marcos was legal, respecting due process, their rights, and respecting due process, their fundamental rights as citizens of Edea. Your Excellency, Your Excellencies, we have the opinion that this results in a sentence prescribed by law by the courts, and this affirms the commitment of the Republic of Edea to the rule of law. Your Excellencies, with our arguments, we seek the following relief before this honorable court. Your Excellency, in light of the strong arguments which we have made, the respondent praised this honorable court to grant us the following relief. 1, that the Republic of Edea did not in any way violate the African Charter or other instruments regarding the Bashi people and the child workers. Your Excellency, we invite this court.
Thank you, Counsel. Counsel, we have your brief of fact before us. I will definitely take cognizance of your prayers. We are very, very grateful for your time. Let us hear. It's time for the reporter from the applicant. Applicant, reporter.
Yes, Your Excellencies, we're here. We still remain applicants, counsels for the applicants. Your Excellencies, the respondent team has made unfounded claims with regards to the violations committed against the Bashi people, the child workers, Mr. Jude and Mr. Marcos, and their public order acts, actually. With regards to the withdrawal of the respondent state, we humbly submit once again that it is invalid as it violates the provisions of the Charter and the vested rights of veterans. Now, if we are relying on the principle in Ngabire and Rwanda and the LIDHO and Cote d'Ivoire case, still relying on the principle of the Vienna Convention on the Law of Treaties that 12 months note waiting period after every withdrawal is mandatory for every state before the withdrawal can become effective. Moving on to the respondent state's unfounded claims on the fact that the JJCR recommendations were thorough and they were enough to satisfy the people of Bashi. We humbly submit that the remedies were insufficient, inefficient, and they could not meet up with the violations that were even committed against the people of Bashi and the child workers. If I may refer the courts to paragraph 10 and paragraph 23 of the fact, we will see that and paragraph 20 as well of the facts, the child workers were still subjected to heightened health issues. The respondent state did not reply, did not make any advance recommendations to that. Also, the remedies or the recommendations of the JJCR with regards to compensation, they were also insufficient. Moving on to the validity of the Public Order Act, the respondent state states that the 14 days was proportionate. However, relying on the principle in Ajavon and Benin, the restrictions must be proportionate, they must be necessary, they must be legal, and they must not be vague, and they must not be too excessive. 14 days, once again, according to the general comment, is too long. They must be within 48 hours or ideally at most 5 days. Moving on to the various treatments meted out on Mr. Jude and Mr. Marcos, we humbly submit that no proper investigation was conducted on the part of the respondent states. The respondent states alleged a violation of their own constitution that Mr. Jude and Mr. Marcos were involved in property destruction. However, from the MOOT facts of paragraph 27 and 28, we can see that there was no situation or scenario whereby Mr. Jude and Mr. Marcos actively engaged in property destruction. This, once again, was perpetrated by violent thugs and the police officers. Moving on to the state's responsibility for QHL's actions, the respondents humbly submit and put forward again that the respondent state's responsibility flows from Article 1 of the Charter that mandates is to give effect to the provisions of the Charter. And the fact that the respondent state is a state party, or as committed to the office of the Human Rights Commission to give effect to the provisions of the United Nations Guiding Principles on Business and Human Rights, gives the respondent states the responsibility to ensure that the violations committed against these people are properly redressed. If they cannot be prevented, then they should be properly redressed. This concludes the rebuttals from the applicants. Thank you, Your Excellency.
Thank you very much. Thank you very much, Team 15 and Team 18. So now we just want 1 minute or two feedback from the judges. And I mean, because I'm very sure you guys will be going for your other session, maybe tomorrow or thereabout. So just 1 minute or two, piece of advice from the judges. So I'll start from Judge Benga Ajayi.
All right, thank you. I must commend the two participants. You did very well. You did very well. One of the things I need to talk about, especially with the respondents, you used a particular word. You said you invite us to reason with us. Those are not legal words. You don't invite the court to reason with you. You argue your points, you argue your facts based on the evidence before you. Then I also observed that the case, the Russian case you brought in, it is very important. You must understand that when you are in court, you don't bring cases that you are not abreast with the facts. We in court rely on the laws, we rely on stare decisis, what the court's pronouncement in each of the cases. So going forward, when you are coming to the court, you must be sure that you have the cases and you have the facts, because the court will want to ask you for the authority and for where the premise is coming from. But in all of these things, I must commend both participants. You did very well. Thank you so much, sir.
Thank you very much, Judge Ajayi. So we listen to Judge Itunukolade Fasheyi.
Thank you, sir. I would like to commend the efforts of both teams and to what Dr. Ajayi just said. If you are coming to court cases, in the case of XYZ, the court held ABC without knowing if the cases can fit into what you want to use them for. So I would say we should take note of that. And well, in all, we've done well. I must also commend Oralist 2 of team 15. You did well, and it can be better. Then for team 18, like the last speaker said, if you are relying on cases, don't just read or note the head notes. Ensure that whatever case you are relying on, you know what has happened, you know if it fits into your situation before you cite them. Thank you so much.
Thank you very much. Number one, I want to congratulate the two teams. You have really done well. You have put up a very good fight. I just want to say that I've participated as a judge in several competitions like this, but the two teams are very good, and then I commend you guys. And I'll not be surprised. I will be surprised if any of these teams do not emerge or arrive at the quarterfinal. I think by my instincts that one of these teams will definitely proceed, because you guys are really done well. I'm really pleased with your argument. And then what I think you should do is that try to look at the facts, look at how arguments are to be done, look at what arguments are to be done and all that. You get it, and then get yourself familiarized with the international instrument. Don't forget, this competition is founded basically on 3 legs: international human rights law, international law, and then the facts. So you want to know the facts. What's the position of international law? What's the position of international human rights law? Once you are good with those 3 things, you are good to go. But definitely, I think I would like to see your faces again, possibly at the semi-final or at the finals. But wishing you all the best, and then have a lovely day. So you can exit the room while we deliberate among the judges.
Thank you, sir.
Thank you, sir.
Well done. Well done. Well done.
Thank you, sir.
Team 15 and team 18, well done.
Observer 18, team 15, you have to leave the room. Observer, leave the room. Observer team 15, leave the room. Observer team 15 is still here.
Dr. Ituno has left.
Yes, Dr. Ituno not have left. Observer team 15, okay, thank you, you have left. So, Dr. Benga, how did you see the exercise?
Well done. Well done. Very good.
Guy.
Very impressive.
I mean, it's quite exciting. The first team applicant, they are very, very good. They are very,
very well. Good. They did very well. I'm really impressed with them. That Oralist 2 really did very well. They both did well.
Yes, for me, I felt that Oralist 2 ought to have been Oralist 1 for both teams.
I'm telling you, Oralist 2 in team 15 did very well. Should have been the council. Why the other would have been the co-council? But no, it was beautiful.
What can you say about it?
Dr. Tunu?
We can't hear you. We can't hear you. Unmute yourself.
I said they tried their best now. But for me, I'm impressed.
I mean, the first team did very well, right?
Yes, the lady for what team now? The first
Team
team.
15.
Team 15.
And so I was wondering why she was number 2 and not number 1.
Abi?
Maybe to give us a good impression, good lasting impression.
Yes.
So yeah, I think it's to have a good lasting impression and to cover up for the first person.
Definitely.
Overall, they've tried their best.
Yeah, thank you very much. So, Dr. Benga, I will see you some other time. Thanks very much for your time. We deeply appreciate. So you do the email will be sent where you send the score sheet.
All right.
Okay.
Yeah. Thank you very much. We are grateful. So bye for now. Yeah. Bye.
Thank you.
All right. Thank you, sir.
Bye. Yeah,
Have a nice day.
You too.
Yes,
Yeah.
sir.
You too. Thank you, ma. All right.